Okay, we're back on the air. I again don't understand why the live stream broke. They gave me new software, I loaded it up, it seemed to be working fine. I couldn't break it except on a real show. Whoops. So, Charles, I want to welcome you again to live stream. Can you please just start fresh, because I'm not real sure when our streaming stopped. But Charles is an attorney, a heavy-duty foreclosure defense attorney in New York State. He doesn't understand the problems that we're having because in New York, evidently they've got good laws, they've got good judges, and of course it is a judicial state. When the foreclosure starts, they have to file a lawsuit. Is that correct, Charles? They send the homeowner a lawsuit, so then the owner can hire someone like you to go into court and represent them, right?
Yeah, you file an answer. The plaintiff, which is usually the servicer or the actual trust, files a summons a complaint, and the borrower or defendant will file an answer. And then there's a whole judicial process that follows very, very strict procedures, same as any other litigation in any court, pretty much anywhere in the country.
Right.
And it's litigated. When there's a question of fact, it has to be litigated. And for some reason, from what I've read about California, that whole question of fact thing, like who actually signed the documents.
Right.
I don't think, for some reason, it's like I don't think anybody's paying attention out there.
Well,
it sort of matters here. It's like otherwise I could sell your house. I could, go get a deed, and I could be an agent of whoever, and
exactly.
I could literally sell your house out from under you.
Exactly, and that's really exactly
what's
how
happening
it feels.
there. So I get that's sort of like an emergency. Yeah, it's big time.
Now, what you actually then have done, and you were sharing earlier that when you respond to these lawsuits, you discovered that the person you didn't know who was actually owning the note, who actually was representing the person filing the lawsuit, right?
Wait before that. I don't even care who owns the note. At the beginning, it's not the way I approach this.
Okay, so
how
do you approach
it? I know is that somebody went to, XYZ mortgage bank, in one of these, say whoever, right? Fremont, Countrywide, Option One, it doesn't matter.
Right.
And they borrowed from them, and they have a trust foreclosing on them. And I'm like, okay, great. Well, I look at the record, and there's, the first things that I started to notice was like, well, Countrywide went out of business in whatever it was, '09, or Lehman went out in '08, and BNC Mortgage went out in '07. And I see assignments from BNC Mortgage in 2010. I'm like, how the hell does that happen?
Right.
They do is it like Dracula rising from the dead? We like some kind of cheap B horror movie.
Exactly.
Comes, they push the top of the casket open, they come out, they sign the assignment, then they go back to being dead again.
Exactly.
What happened? It's a question to ask, right? It's like,
exactly.
You don't even have to be a genius to figure this out. It's like, well, they're gone.
Exactly.
It's just saying, listen, it's no different than if, like say your aunt Tilly dies,
right?
And someone wants to inherit all her property, especially her $3 million house on Great South Bay,
right?
And she's dead in October of '07, and in 2010, Aunt Tilly signs the
exactly.
Aunt Tilly signs the deed to her house to her nephew.
Right.
Look, it's the same thing. It's like, well, Tilly's dead. How did she do that?
Right.
Can't sign that, right? And it's like you can make the same analogy for a corporation.
Exactly. And so is this what you've started to do? You've been doing this now for years.
Other things, yeah. It's like
challenging
on that. You have to know what happened.
Exactly.
You have to have some background into the story, and say, well, this is who this is. You do your research into the entities that are the agents for the principals, right? That's really what this is all about. It's all about nothing more. This whole MERS thing is about who's the agent, who's the principal. MERS keeps saying that they're a principal, and I'm like, no, you never own the note. You're not part of it. You didn't loan any money. You have no beneficial interest in the transaction, except being like a big chalkboard, where entities that are members track the loan internally. I'm like, well, how does that make, how does that give you authority to do anything?
And so then...
But if appeals here said they didn't, so...
Exactly.
There are no more MERS foreclosures here.
Right. Right. So you don't really have to challenge then for MERS to show beneficial interest, or that they would be the beneficiary, because it doesn't come up now.
No.
Okay. Not in your state.
Because the Court of Appeals said so.
Right.
They said, "Who are you? Who are you? Why are you here? What is your role in this transaction?"
Right.
I got to tell you, listen, from the stories that I've heard around the country, I am lucky because we have the same laws on our books that every other state has on their books. We have laws that are hundreds of years old here that go back even to England, ancient Rome. You own property, you own property. You are a bona fide owner. It means somebody cannot come and civilly attack the chain of title because you have a recorded instrument, and that is what protects the chain of title.
Right.
And you have to have you have to be a principal. In other words, you have to be the person, right, the owner of the fee interest or the any interest in real property. It doesn't make a difference with riparian air rights, the right to cut lumber, whatever it is. You own that, and you can transfer it. But you have to be, if you're going to transfer it, you got to be the guy that owns it, or their designated beneficiary,
right,
or their designated agent,
and be able to prove that.
Yeah,
yeah.
That's what it's all about. I mean, that's what it's all about here. It's all about that. It should be about that everywhere.
Exactly, and obviously the people struggle in a state like California to make it about that. Now you've talked to me a lot about, and you use the phrase shifting the burden. Can you explain a little bit about how you do that?
Yeah, sure. It's a little different in California because you guys are you're a title theory state, and you have and you transfer property in foreclosure pursuant to notice of sale and then power of sale.
Right.
The statute. And it's like, yeah, it's typical. It's like any other title theory state has got pretty much the same thing. But there's no judicial proceeding.
Right.
At the end of the day, the plaintiff would be the homeowner who is getting wrongfully foreclosed.
That's right.
And, they have the same thing in Massachusetts. Massachusetts is a title theory state, but boy, let me tell you something. It's not that easy to foreclose there.
Right.
I mean, it used to be, right up until a fellow named Glenn Russell, who's had it up to his eyeballs, and a few other people got good and pissed, and he just, he's the guy who just won the Ibanez decision.
Right.
There, which pretty much put, MERS way back on their heels. But the trial courts don't want to hear it there either.
Right.
They don't want to hear it. They say, whatever, I'll get out of here. These people borrowed the money. Yeah, I borrowed the money. I borrowed from them. I borrowed from Y is foreclosing on me. How did that happen? And no one wants to hear it.
Right.
They do. Let me explain to you. Yesterday, I think I might have told you this. I may not have. It might have happened afterwards. About 4 or 5 o'clock yesterday, a referee. We have referees here that actually, after the foreclosure, they appoint a referee, calculates the amount due.
Okay.
And then the referee is the one who's vested with legal title to the property, so they can actually go and sell it. So when the property is sold at foreclosure auction, the referee is the one, like John Smith would be the referee. As referee, would be transferring title. His name's the referee's date in his name. He's the guy signing it.
Okay.
So the court gives him the power to exercise that what you would call power of sale.
Right.
A referee called me with a basic thing and said to me, I have an assignment of mortgage here, and it says Washington Mutual, and it was an assignment of mortgage in 2011. And she said to me, didn't Washington Mutual go out of business in like 2008? And I said, yeah. She goes, well, how is there an assignment of mortgage from Washington Mutual to Chase in 2011?
Vampiredom.
And I told her exactly. I told her the whole story of the WAMU FDIC
Yep.
Uncle. And she's like, no kidding. And I said, yeah, no kidding. So this is a phony. And I said, well, you said it, I did.
Exactly.
And I said, well, who made this document? I said, I don't know. Look at the person who signed it. I didn't sign it. You didn't sign it. But I said, I'll tell you one thing. You're the first person, I think, in the history of New York State, maybe in the entire country, you're the first referee in a judicial state to ever question the chain of title.
Right.
She said, well, what should I do? I said, well, if you sign the referee's report, which also affirms, the referee says that the underlying action, that there's a cause of action there. Right. They don't have a real big duty of, they don't have a substantial duty of due diligence. It just sounds right? It's like, okay, there's an assignment here, assignment. So they don't have to be Sherlock Holmes and investigate this thing. But
right.
This one is so bald faced.
Right.
Well, listen. She was also at 3 of my seminars, so she knows the lingo. She knows what's sort of happening.
Right.
So she said, I can't sign this, and I said, well, you probably can. She said, I would be violating my oath. I'd be signing something that I knew not to be true, or had cause to believe not to be true.
Correct.
I said, so don't sign it. So put it in your report saying that you cannot sign. You could sign everything in your report but that the money's right, that they did take a loan on this day, they may or may not have defaulted, but you could say certainly that this is a fact that comes to your attention and blah, blah, blah. And the judge will read it and he probably won't sign, he won't confirm the referee's report.
Right.
In which case, the foreclosure is dead.
So then what...
You understand, this is the first time this has happened.
But what this is what I heard you say. You said that she'd been to your seminars, so she has some understanding. And then obviously she's looking at the documents. She knows where to look. She knows how to read the names.
Of course. Yeah, no,
yeah.
Listen.
Yeah.
Who knows? Listen, until you learn how to do something, you don't know how to do it, right?
That's right. And you don't even know what's coming before your eyes. Mm-hmm. It has the patina of legitimacy, like you've talked about. It looks right, and so, pass it on. But as more and more people understand what they're actually reading, then they start to question it, just like you were saying.
Listen, there's nothing about this that is so unbelievably difficult that it can't be figured out, right?
Oh, exactly.
Nothing. I mean, everybody gets lost in the securitization stuff, but you look at the securitization, and you look at the pooling servicing agreement or a mortgage loan purchase agreement. You just want to find out who's who and what's what. When this was supposed to happen. That's other than that, you really that this whole forensic stuff with charging people charging $3,000 for a forensic examination information. Right. I can and do find out in 15-20 minutes.
Right.
Right. This is what should have happened. This is what did happen.
Right.
The thing that we really have going for us is the level, is the sheer volume that these foreclosure mills, the volume of paper that they have to turn out. Phony paper.
Right. It's just an assembly line. Stamp.
Yeah, the assembly line,
mm-hmm.
They get it wrong regularly, and then they record it. So it's not like you can ever take that back.
Exactly.
Record these documents. So it becomes part of the public record.
Exactly. That's been my advocacy, and in fact, I've analyzed all the documents on 18 properties that Recon Trust, their forgery mill, has produced, and literally every property has so many problems with the actual just recorded documents, either false notarization or forged signatures.
You gotta understand, CJ, I gotta tell you, you tell this story for the first time to somebody.
Yeah.
Same thing happened to me, a few years ago.
Yeah.
Out of 30, 40, 50 judges or their law secretaries I would tell the story to, they look at me like I'm nuts.
Exactly. How could that be?
How could that be? And no one
Right.
would believe that, we had the Stephen Baum scandal. I think it was another guy in Florida. I think his name was Stern. Can't remember his first name. David Stern. And no one would believe that they would run these document mills. Like, it didn't matter. Like, who's going to feel sorry for somebody who didn't pay? I got news for you. I have about 175 clients here, I guess, 150, all in foreclosure. I'm defending every single one of them, litigating every single one of them, successfully, might I add.
Yeah.
And it's only because that the judges care.
Right.
It's only because they care, because, like, at the end of the day, the judges, if the judges have jobs because they are good at making sure that the trier of fact, whether it's the court or a jury, that they're entitled to the truth, as the truth has to be told according to the oath that they take. In other words, like, they swear to tell the whole truth, that thing, and that it's like a felony not to tell the truth, like called perjury.
Right.
And you have a big fat book with small print and a lot of footnotes called the Rules of Civil Procedure, that the truth comes out. They are not, they're sometimes the arbiter of truth, but they have to make sure that whoever's trying a case tells the truth.
Right.
And they realize that once that they do not do that, no one will need them. If the truth doesn't matter, then the courts don't matter. Courts don't matter, judges are out of a job. And if it came right down to foreclosures, if things are as bad as you say they are, who the hell needs a judge to even sit on a foreclosure?
Exactly.
And not just say, you know what, we don't even need judges.
Exactly.
Let's just put people's houses in pawn shops.
Because we're not even, because you go to court, you can't get any justice, you can't argue the law.
Do me a favor, don't use that word.
I'm sorry. You can't argue the law.
Understand this. Justice is not justice is something that everybody, you have to pay for that. You pay for justice. Okay, justice is something that a court gives you a shot at. Doesn't mean you're going to get it.
Right.
It means you have a shot at it. And whether you're going to put your own time, which is worth money, or a lawyer's time, which is worth more money, because that's supposed to be their, in theory anyway, right? That's supposed to be their expertise.
Right.
A shot at justice. And when you don't have a shot at justice, you're in Stalinist Russia. Because there is no shot at justice. No one would even say that there's any type. There is no due process. There's no process. And when a judge knows that somebody is lying to them right to their face,
yes,
and allows them to do that, that is not a denial of justice. That is a crime.
So Charles,
it's not a denial of justice. That is a crime. You're talking about like the Jim Crow South.
Exactly. So,
right.
So, do you have any suggestions of what we can do when we're faced with this?
Well, I got to tell you, I don't. One thing in my heart that maybe I don't want to believe it. Maybe I'm like a little bit of a schmuck that way. But I don't want to believe that every trial court judge in California doesn't want to hear this stuff. I got to believe that you need a new strategy. Number one,
right,
to bring the issue up outside the context of a non-judicial foreclosure where you're trying to object to a wrongful foreclosure or a wrongful notice of sale.
Right.
Outside, you need a new strategy. Somebody over there's got to think out. Well, I've already done this really, but I don't practice in California. I practice in New York. But if I were in your state, I know what I'd be doing.
Okay, so tell us, what should we be doing?
Well, if you think it's got practical problems, right? Of course, but in theory, the minute the notice of sale, you'd have to go for your order to show cause, and then you would have to bring up the fact that whoever it is that has assigned the trustee? Is that who it is? The trustee gets to sell a property out there?
Yeah, it's the foreclosure trustee.
Whoever assigned the trustee that right of sale, that's a real assignment.
Exactly. So you have to challenge the assignment.
You have to check. Well, that's where it's at. And I'm glad you're bringing this up because we're coming around full circle now. Because the same theory of law that I use here is the same theory of law you're going to use there, which is it's principal agent.
Yeah, it's like who are you? Like you said, I love what you said. You said,
and what are you doing here?
Yeah, the homeowner borrowed money, but he borrowed from A and now he's paying Y. And how do you get from A to Y?
It borrowed from you.
Exactly.
You know what the bigger problem here is? It's like, and this is something that judges really don't know, and because they haven't thought about it, not because they can't figure it out, just haven't thought about what the real danger is here. Because listen, it's like there's no denying that people borrowed money,
right?
And there's no denying that in many cases they can't pay it back,
Right.
or there's no reason for them to pay it back, and they should be modified.
Right.
But the real problem here, is the destruction of the chain of title.
Yes.
Sooner or later, these putback cases, because of breaches of representations or warranties,
yes,
or just outright theft.
And explain.
By the way, between these pools, yeah, the sellers, the sellers, the sponsors, who the originators are, who the depositors are. There is a ton of real stealing going on there. I mean, I could point out probably half a dozen cases. These loans are getting put back. They're getting taken out of the trusts and put back to other parties. Originators, the successors and assigns of originators, like they would be put back to Countrywide, but you can't do that because they're dead.
Right.
You'd be putting it back to
B of A,
America, which is exactly what the FHFA just, I think, got a $10 billion settlement and award,
right,
from B of A for this all this Countrywide all-day paper that it stuck Fannie Mae with,
right,
5 years ago. But that's a real putback case.
right.
What happens when someone from one of these trusts says, the actual certificate holders, the investors say, something? You guys don't own that loan. I own that loan. Or there's a conflict in between two of them. And there's going to be, and that's a quiet title action.
Exactly.
They're a competing interest to the same claim in real estate. Then you need a quiet title.
Exactly.
Quiet title isn't just about isn't just about extinguishing a mortgage or expunging a mortgage from the record. It's a quiet title is literally saying, there are two parties or three parties or 10 parties competing for the same interest in real estate.
Exactly.
On the same lien, which is what's going on here. Well, you don't have liens for the same deed of trust.
Exactly. Exactly.
That's the problem, because this is right now. It's easy. You can figure it out. There's supposed to be paperwork, and if you can't, you can modify it. What happens when the person who has the authority to modify a loan, in other words, the borrower, is gone, and somebody else, another entity, has a fee interest in their property, in that same property?
Exactly.
Now you're going to get a bunch of those big banker boy lawyers at $900 an hour, and their little train of little ducklings behind them with the big briefcases, and they're going to be jamming up the state courts arguing about who owns what.
And we already are hearing. We're already
down the road. Are you kidding me?
We're already hearing anecdotal evidence. Stories about, for example, some lady pays off her loan in full. It's never reconveyed, and so they foreclose on it. And then some other entity comes to try to foreclose on the property. And the fear, I've got contacts right now that are not in delinquency. They are current on their loans as far as they know, because we already know that the servicers try to push people into delinquency by playing stupid games and not applying the payments correctly and stuff like that. But these people are current. They want to pay off the loan. They don't know who to pay. And they are now scared because the loan, in this case, serviced by Ocwen, and so she calls to say, okay, I want to pay off my loan. And then, of course, she's transferred to somebody else in some other department. And the last person she's talking to is somebody over in the Philippines who says, oh, well, you can make this payment.
I get it.
It's just a mess.
The attorneys that show up in court are no better.
Yeah.
I had a case today. I was in court this morning. Just to tell you about the quality of our judiciary. I didn't really have to say a word. It was beautiful. Woman was in my client was in a mod, paid for 18 months, thrown out of the mod,
right.
And the reason that the service had threw her out of the modification, she made 18 payments, and it was a trial. She's supposed to give it a permanent. That nonsense. But this is before she was my client, because I would never have let her do it in the first place.
Exactly.
She was thrown out of the mod after 19 months, or 18 or 19 months. They claimed that she's in foreclosure. They had filed the summons of complaint. They claimed that they did not know the pretext for removing her from the program was that they did not know she had a second mortgage. And I pointed it out today to and the judge said to the attorney, "How did you not know?"
Exactly.
And he said, "I want to see the modification application."
Exactly.
And I said, "Your Honor, I held up the summons of complaint." I said, right after the defendant, right after the homeowner, that lender, the second mortgagee, Was named. I said was named in the caption.
Our paperwork we sent named it, but we don't know.
I said, so they said they didn't know.
And so what happens? What did the judge do?
The judge looked at her and said, you know what? Here's one of two things is going to happen. He says, you're either going to withdraw your motion, or I'm going to dismiss it. He said, you keep in mind that I'm the judge on this thing right to the end.
Right.
So I'm going to give you a choice. You have till Monday to figure it out.
This is the lunacy of this whole.
But that's New York. You see, that's New York. Because this judge, for some reason, he kind of just hates when lawyers come in and bullshit him. You know what I'm saying?
Boy, wouldn't that be wonderful? we could really appreciate some judges like that.
You can't tell me, like as an attorney. Listen, I was afraid to lie to my mother. I was afraid to lie to my father.
Exactly.
Listen, yeah. What is you get the wooden spoon, or you get
exactly.
they whack you across the butt with a strap or something like that. You lose your career. You know what I mean?
I do.
Or it makes it really, really difficult for you to practice because any of the words that come out of your mouth are you get a presumption that you are a liar.
You presume.
When you have to go to court and tell judges things and like they're supposed to believe you. Here, like you kind of make, as an attorney here, you make a living on credibility.
Right.
Yeah,
right.
And it's like you say something. Well, the guy's been doing it. I've never heard him lie in 20 years. Why is he going to start now?
Right. Boy, oh Charles.
It's like okay, Your Honor, they're in the caption. Here it's like here's like Mrs. A, Mrs. A, Mrs. B, and Mr. A, and then blank blank bank, right?
Right.
Caption. So you didn't know them. You served them. You served them with a summons to complaint. What is that like? That went over your head. You didn't realize it. It was a mistake. You're blind. You can't see black ink. You're colorblind. Are you blind? Which part of this aren't I getting? Because there I am back to the Twilight Zone again. But the judge lost his mind. What do you mean you didn't know? It's in the caption.
Right.
And by the way, it happens to be on the application, which I had right next to the summons complaint, because she said we didn't know. Because I've heard this stuff before.
We've been chatting.
I'm sorry. No, she's got blue eyes. It's in our manual. We don't give people with blue eyes modifications.
Yeah, but see, Charles, what you're talking about is the Twilight Zone, and California's in the Twilight Zone. Trust me.
Because well, even before this crisis, I believe that California had a little bit of a reputation of being a little bit of a Twilight Zone.
Well, they said it's the land of fruits and nuts. And the trouble is, most of the people that live here are not in the Twilight Zone, and the people are begging for this kind of support.
Everybody in the country, they have to enjoy a little bit different of a lifestyle, and like people in Florida want to live one way, and people who live in Alaska want to live another.
Well, and Charles, before we go, I want to just
laws, right? I mean, it's like there's one constitution and one this and one that, and that's what there is.
Right.
And the very cornerstone of American law is the right and protection of real property and personal property. The right to own property and the protection of property.
Yes.
And this is all not a good thing for that.
Exactly. This is just a rampant taking, a theft enabled by the court systems, as best I can ascertain from all the people that have tried and not worked. You and I have talked about you're coming out here to California to teach a seminar or a series, several sessions in.
Oh, I'd love to.
So
something, I would love to do that. I think you should contact every attorney, and I'll bring some people with me. I'll bring some of the hot shots I know with me.
So tell us what you would
we've been fighting this fight for a long time, and now it's time for you to start winning something in California.
Exactly.
You can't tell me that if you go to an appeals court in California and you say, something, this lender is a liar, this trustee is a liar, but the document is phony, and they lied right to your face. What are they going to do? What are they going to say? No biggie, no big deal, it's okay, whatever. They come on.
I think it's going to be.
Judges have to hate being lied to. It's right to their face.
I have to think it is going to take, some real effort to get these kinds of judges and decisions on behalf of the homeowners, basically pointing out that the attorneys are lying and that the documents are forged. I think it's going to take
the first thing you do is you find the documents, right?
I know.
You find, well, this is what I teach here. I said, this is the document that they're using to actually substantiate their prima facie standing in the case. In other words, they are the entity to be paid.
Right.
Well, okay. Well, that I can usually throw some doubt on that.
Absolutely, blow that out of the water.
Which means I'm shifting the burden back to the plaintiff.
Exactly.
The problem is that in the proceedings that you bring in a title theory state, it's usually after the fact.
Right.
So what we really have to do is we have to bring the type of proceedings before the fact that puts the burden on the entity that would foreclose to prove that they have standing. In other words, that they have a beneficial interest.
Right.
Loan that they are entitled to.
Didn't you call that
their rights are superior to the person who owns the right of redemption, which is obviously the homeowner.
Right. And didn't you call that a declaratory lawsuit?
Declaratory judgment, right. Yeah, they give them all the time on everything else but this, right? So, I don't know. We'll figure it out.
Exactly.
I don't practice in California, but I know exactly what I would do.
Right.
And I'll tell you something. I'm one of the few attorneys here that do this. I teach every other attorney that I can get my hands on. Like between the two counties in Nassau and Suffolk.
Right.
There's something like 30,000 or 40,000 foreclosures, all judicial.
Right.
Moving through the system slowly.
Right.
And I've got a small. You think there's not enough business?
Exactly.
I could teach the next 200 attorneys exactly what I know.
Exactly.
I wouldn't be missing a beat. I'm not selfish about this stuff.
Exactly. There's just so much.
It makes it easier for me, right? If instead of a judge hearing it from me, now they're hearing it from me and 100 other lawyers. Okay, well somebody must know what they're talking about.
Exactly. It makes your job even easier because more and more people do understand and more judges understand and make better decisions. Yeah. So
it's not that we're progressive. I think the judges understand that if they don't deal with this now, if they allow the chain of title to be destroyed now,
yes,
the whole principle of the United States protecting property ownership. You got to understand the guys that run these huge corporations, they own property too.
Exactly.
So if the law is for me, the law is for them. The law is for everybody, for every little piece of property that is owned, whether it's small or big. Those are laws. They've been around forever. They've been around since Rome. Same laws. They've written in different languages. Okay, but it goes up through the English common law. And it's been the same thing. No matter where you go in any developed country, you know what they do? First thing they ever did was protect private ownership of property.
Right. Right. That's the basis of wealth in the middle class. I mean. Yeah.
And to do that, you must have a reliable title ownership recordation system. In other words, you can pass marketable title.
Exactly. An honest system, a system that hasn't been corrupted.
It's accurate. It's called it's like when you buy something, you're a bona fide purchaser. You're a bona fide lender. You're whatever it is that you are bona fide. You take free of defenses. You've taken for without notice and for value.
Right.
Yeah, that's what a bona fide purchaser is. And let me tell you something. You guys, you are destroying those. They are destroying. They're destroying title to real property. And
exactly.
Just going to backfire. Funny, the thing that's ironic to me is that, well, what happens when these lenders in 5 years, 10 years, when they want to lend on real property?
Exactly.
They want to lend on this thing. How are they going to get a mortgage policy?
Well, and this has already come up. This is already an issue. In Washington, they're talking about passing a law where the banks can just foreclose and not even on foreclosures, it's just on all title, that anybody that has a loan that needs to be paid off by any lender, and a lot of times when the money goes to the lender won't reconvey, and there's no real guarantee anymore that that payoff is going to the correct party, just like you're talking about. And so they want to pass a law saying it doesn't matter, that banks doesn't matter. Basically, you pay any bank, and then
okay, like to see that.
Yeah, well, and then the bank or some like I talk about a corporate shell game entity indemnifies the title company for any problems. You know.
Oh yeah, I know. And then they close their doors and say sorry.
Absolutely, absolutely.
We can't help you.
And everybody, the people are going to just take it. You know, they're going to take it. They're going to be on the hook, and at some point in time.
I don't think that's going to happen. I really don't think it's going to happen.
What do you don't think is going to happen?
I don't think that the Washington legislature is going to just, and they couldn't do it anyway.
The fact of the matter is, the banks and the title companies are pushing for this.
That one will go.
The banks and the title companies are pushing for it, and
I don't care who pushes for it. It ain't going to go. And if it goes, it's going to be unconstitutional. Just because you pass a law doesn't make it right.
That's correct. But now it's another battle, and some owner is going to have to step up and fight.
We've been fighting for our freedom. I mean, you've been out to Gettysburg.
Yeah.
You ever seen Normandy?
Yeah.
There are a lot of crosses sticking out of the grass.
Right. A lot of fight for freedom.
We've been fighting for a long time. Yeah. That's what we do. Americans fight.
Right.
That's what we do.
Yeah, we have to just keep up the battle.
Yeah, guess who we fight with?
Well,
Charles,
Charles,
this when they wrote the Constitution. Yeah, we fight with our government. Why? Because that's what they did.
So
that's what Jefferson and Washington and Hamilton, all those guys. Yeah, they all fought with the government, except it wasn't the United States government. It was
right.
They fought the king.
And so you're willing to come out and help us get trained so that we can fight better. Is that right? You're willing to come out and do a seminar if we can round up enough people.
Listen, don't get me wrong. I don't come out like a guru. But I'll tell you one thing. I know a bullshit document when I see one.
Exactly.
And I know how you say this is how you attack the document, the document's relevance to the transaction,
right.
and the relevance to the transaction to the applicable law, and you go tell a judge, this guy just lied right to your face. What are you going to do about it?
Right.
If he says nothing on the record,
yes.
Okay, well, you know what? You check the court reporter. You make sure that she heard that. Okay, so Your Honor, can you please repeat that? And they repeat it. Say it says it twice. And you go to your appeals court. You say, you know what he said? He said it didn't matter. They were lying to me. I'm just going to let this roll. And you know what? It's not going to go on forever.
Right.
It can't.
Right.
It can't. We're Americans. This is the kind of crap that our grandfathers, great-grandfathers, great-great-great-grandfathers have fought. This is the same war, whether it was on our soil, overseas. This is what we fight and die for.
Right.
Yeah, no kidding.
Yeah.
Fight. We fight. And when the truth doesn't matter, guess what? You got to fight harder.
That's true.
Everybody in this movement has to have a little bit of Rosa Parks in them.
Right.
Little bit.
We just won't take it. We just can't take it. We have to fight back.
Yeah. Well, guess what? It may come down to fire hoses and dogs again. How old are you? You're in your 60s. I'm in my 50s.
Right.
I remember that stuff.
Right.
We all do, because this is who it's happening to, our generation.
Right. It's just
remember that stuff. Remember the dogs and the fire hoses.
Yep. It's just really surprising.
Buses. You remember all that stuff?
Yeah. We just didn't recognize that.
It made you embarrassed to be an American, right?
Exactly.
And they did it under the color of law. And then guess what happened? Then they had to change the law. They killed Bobby. They killed Martin.
And right now they're killing homeowners.
Well, guess what?
Yep. Well, thanks, Charles. We just really appreciate your encouragement, and I look forward. I'm going to tell our viewers. I'm going to work with Charles. I'm going to try to get him to come out here. Let's ramp up some enthusiasm for a seminar. Both attorneys, judges, owners, anybody that's willing to understand these kinds of principles and what he's doing to win in court, that we can duplicate here in our courts.
Listen,
to help save our houses.
And gives any of these modification bakers a dime.
Yeah.
Or if you go to an attorney who's not willing to go into court and stand right up to the judge and say, Your Honor, this attorney standing next to me here is a liar.
Right.
Because he's a liar and he's lying to you. Either you care or you don't. And I want you to go on the record right now. Do you or do you not care about this lie?
Right.
And because if he says, well, I care, I said, okay, let's take notice. Is this a fake document?
Yes.
And he says, it may be or it not be. So you're not sure. Okay, good. Let's put that on the record.
Right.
Okay, and then you can go, you have to make a record. You have to know how to litigate a foreclosure case, which, by the way, I don't blame anybody in California for not knowing how to do, because you don't have to do it. They're non-judicial foreclosures. So
Exactly.
why would anybody there know how to do this? You have to take somebody like me from a judicial state who knows how to shift the burden.
Right.
Because they don't know how to do it. You should all, listen, people should put a fund together, pick 10 attorneys, and send them to a class.
Exactly. Exactly.
Because they don't know how to do it. No one would ever train a lawyer in California, how do you defend a foreclosure? You don't. It's a non-judicial foreclosure.
And quote, there is no defense. You borrowed the money you didn't pay, so we're taking the house.
What are you kidding me?
Yeah.
Every lawyer, listen, I don't know, it's a big state, 25 million people. Any lawyer who's going to listen to this or is going to hear about this at all, boy, let me tell you something, you can make a lot of money. Because the people who are getting foreclosed on, they're still working.
Exactly.
Probably, they're working, they're just maybe not making as much as they did.
Yeah.
If you know how to do this, this is a big business. You
Right.
can get paid.
Right.
Homeowners and people in foreclosure are not deadbeats.
That's right.
That's right. They got kicked around a little bit by the economy. Well, you know what? So do all those big banks, and they didn't mind taking $5 trillion from the taxpayers.
Exactly. Exactly.
So you know what? A bit on both sides. It's a Yiddish word called rachmanis. Means sympathy or empathy.
Yes.
It's feeling. Right. So you know something? This goes both ways. We're not going to let this thing turn into a cash cow for the people who caused it.
And right now it is. Right now in California, it's a
There's
huge
nothing
cash
wrong with
cow.
the big banks. You need big banks because the Federal Reserve can't distribute money by themselves. They need kind of like, wholesalers, which is really what they are.
Right.
They're wholesale outlets for money. That's what the big banks are. You need big banks. You need them. Are they trying to make a profit? Yeah. Okay, that's an American, that's a tenet of being an American also. It's like, I am here, I support capitalism. I support a free economy, the freedom of speech, all these other things that go into being able to live the way we do. This is what it's about. But, you know what? At the end of the day, our founding fathers created a judiciary. That's what they did. They created a legislature, an executive, and a judiciary. And they did it for a reason.
Right.
Yeah. Whatever. Listen. If you guys are ready, I'm ready.
I'm ready. Are you guys ready? Let's bring him out here. Thank you so much, Charles, for sharing with us. And
It's a
truly,
pleasure. You have me on anytime.
thank you. Truly, I think you've hit on one of the points and why. How would an attorney learn this kind of litigation?
Where you're going to learn it out there because you don't need to know it.
Yeah.
There's such thing as a judicial foreclosure. You have to turn
Exactly.
these things into judicial foreclosures.
Exactly.
Obviously,
That's
it's not
great.
going to become a judicial foreclosure state. But what you would do is you raise an issue of fact as to standing,
Right.
as to authority, some type of contractual authority to do something, and then you shift the burden to the lender.
Right. And then you get everything on the record.
Well, guess what? Something's going to give you a little bit of trial and error, and I'm not licensed to practice in California.
Right.
So there's going to have to be California attorneys doing it, and
Right.
you know something? They're going to get paid if they try.
Exactly. I mean, there's just people clamoring for this support. We're pushing this as fast and hard as possible. So if anyone watching knows of any attorney that's willing to try this, to work with us, to develop a system and a strategy that would help homeowners actually go in and do the declaratory lawsuit, even those that are not in default, to insist before it turns into a foreclosure that the entity, the servicer, prove they have that right, I believe we could actually set some real standards and maybe move California forward into getting stopping, the theft of the houses. Charles, thank you so much. I'm sure that we'll be coming back and having you on the show again. We appreciate your time.
Have a good one.
Thanks, you too.
Bye-bye.
Bye now. Well, guys, that's it for today. It's been fun. I've enjoyed it. Let's hear how we're going to leave the show today, and we're looking forward to tomorrow. Talk to you soon. Bye.
When I was a lass, I was proud of me class, like my father and mother before me.
They taught me to fight for my civil rights,
But it's always the same old story.
the rich reign supreme while the poor can but dream.
Under Labour or Liberal or Tory. And I say, bugger the bankers and politicians, bugger the bureaucrats too. Bugger the buggers who make up the rules, and if you're one of them, bugger you. And if you're one of them, bugger you.
The system is bent and the money's all spent. We're measured from every direction.
The workers get taxed while the wealthy relax, with nary a moment's reflection.
Where there's brass, there's muck.
And they don't give an arse, 'cause they're programmed against insurrection. And I say, bugger the bankers and politicians, bugger the bureaucrats too. Bugger the buggers who make up the rules, and if you're one of them, bugger you. And if you're one of them, bugger you.
Now all you good people with passion to vent, don't give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent.
By loitering women